Hi folks, so it's Court Wingman here. I am Alex Woods, your host for today, and I have with me this afternoon Daria Sietkovska. Would you like to
Hello.
announce your presence?
Hello, everyone.
Now, we've had a lot of building disputes just quite recently come through Court Wingman. Some have had to go to the partner law firm in order to be litigated there, but obviously where possible, Court Wingman is a litigants in person support service. We try and help you to do it yourself. Now, we're going to just cover a number of kind of key areas. I mean, the channel has got a bunch of videos. You've got the book Flying Solo. There's a building dispute section in the book. The general principles would apply to a building dispute. The general litigation principles would apply, and you can use the information that's on all the videos on the channel. But obviously, there are some special features of certain areas, and this is particularly true of building disputes. So I will put in the description box below the order in which we're covering things, so you can go directly to the issue of the day that concerns you. This will be a 30-minute podcast. It's audio only. So let's just simply get cracking. Before I get on to the list, is there anything you would like to say generally, Daria, about your experience just recently over the last 6 months to a year of building disputes, and are there any issues that just keep on reoccurring?
I think the issues that keep on reoccurring is the lack of formal contract. Practically speaking, in the majority of the cases, people aren't precise enough when it comes to setting out what they want doing at their property. A lot of things are written on the knee, at the back of someone's house. There is no formality, and I think that the lack of certainty over a lot of issues creates difficulties further down the line, because it's a case of he said, she said.
Yeah, and I guess unfortunately for most of you out there, it'll be too late to be properly drafting up a contract between the parties. However, that's not always the case, and you might be in a position where work's ongoing or listening to this podcast, and you're thinking, well, actually, should I be doing anything now? I think the corollary of the lack of a proper contract between the parties is where extras have been done. I mean, isn't that often the most common area of dispute, that there are extras?
Yes, indeed. I think, as you're going along, the customers of the builders often change their mind, which I think is quite normal for everyone to do. So as they go along, they've got a different idea of what their lounge, extension, bathroom or anything else may look like. And on that basis, certain changes are made. And because they're not formalised, or because they're not clear enough, or the builder will say, yes, I'll do this and that, it then poses an issue later down the line, because the price, the quote isn't ascertained for these extras. And so, there's no one who's the wiser in the situation.
Yeah, so the takeaway there is, if you are feeling that there might be a dispute brewing, is try and clarify with the builder, or with the builder with the customer, what was originally agreed, the scope, obviously, and what was the price for the scope, what was originally agreed. And now you're going to have to do that anyway in the pre-action correspondence if it gets to a contentious stage. So I think it's I think this just brings us on to pre-action issues as far as building disputes are concerned. Where you are, where you have got a dispute brewing, a building dispute brewing, you need to have quite clearly laid out in correspondence exactly what the original remit of the work was and the price, and separate out the extras. I mean, you can almost see the letter being, almost see there being two letters to your opponent in order to try and get some clarity between the parties as to what was originally agreed and what extras were subsequently agreed and what the price was for those individual extras. So it's it's a lot more complicated pre-action than a lot of ordinary claims. And the danger is that if you don't do this and you issue, there are two sort of classic problems, which is, one, you're a builder and you bring a debt recovery claim. You can see it, can't you, Daria? They've just filled in the N1 and they've put...
That's an invoice due.
Yeah.
Interest rate.
Yeah.
That's it. Almost a two-sentence particulars.
Exactly. With interest rate at X. And they may be running into quite a scary situation because it may be that the customer is really unhappy with the works, and so unhappy, in fact, that they've ignored the builder's invoices completely.
Yes. And they bring a counterclaim.
Exactly. And the counterclaim could be even bigger than the...
Yes. Then the original scope
claim.
of work, the original quote, yes. Because what often happens is, and we've had a case like this where... we've had a case recently where it's not just the building works that have been carried out. If it is then necessary to rip out the entirety of the works in order to do the proper job, then that creates a massive difficulty because obviously, especially in today's world, the prices are increasing. There's more and more work that needs to be done, and therefore your ultimate liability may be more than originally envisaged in the quote. So you may have done the work for £10,000, but if another builder needs to come in, rip out the entire, for example, bathroom, because the work has been done so badly and it's impossible to remedy it, it has to be removed, then you may end up with a liability of £15,000.
Yeah, so that's a classic case in point. The other common scenario is where let's put yourself in the shoes of the customer who's had your house or kitchen renovated, whatever it might be. You may bring a claim for faulty workmanship. And the issue there is, I bet Daria knows what... I'm going to use a two-word expression that's common as chips as far as building disputes are concerned. Double recovery. So we've had a case like this that was absolutely, and unfortunately the client didn't seek our advice beforehand, did he?
No.
Did he just brought his own claim, didn't he?
Yeah.
It's quite massive particulars of claim, as I recall.
It was, yes.
Covered absolutely everything, and but unfortunately, he'd also not paid.
The remainder
perhaps
of
you'd
the
like
work.
to explain double recovery to the audience.
Yeah, so sometimes people just stop paying for the works, even though the quote is, for example, at £10,000. I think we'll just do the £10,000.
Yeah, we'll use £10,000.
Yeah, and the builder will consider the works are complete, and on that basis, the final stage of the payments, because normally the clients will stage the payments.
Yep.
So the builder will say, well, that's fine. I need my final £2,000 payment now. But the client isn't happy and they're not paying. And so then they then bring a claim for £5,000. The customer. On the basis that that's what the remedial works have cost them. Now, in reality, if the remedial works are £5,000, but the quote was £10,000, what they should have claimed is £3,000, not £5,000.
Oh, You're getting me there with the maths.
Right, so
just
essentially...
Just lay that down. Perhaps put some flesh on the bones by giving an actual example. Let's say it's a kitchen renovation.
Mm-hmm.
The builder's quoted £10,000.
Yeah.
The stage payments, you say.
Mm-hmm.
So let's
have been
say...
made up to £8,000.
Yeah, so let's say there's a £4,000 at the beginning, £4,000 near completion, and £2,000 snagging.
Yes, at the very end, yes.
Yeah. So in your case, the example is they've paid £8,000. The builder has done the snagging, but the customer's not paying because by that point he's unhappy with the works.
Yeah.
He then goes and gets another builder to do
the works for £5,000.
The works for £5,000. Now,
so
take us through.
If they then make a claim for £5,000, that's double recovery in the amount of £2,000 because they would have had to have paid £10,000 in any event
to get that job. The kitchen
exactly
totally renovated. It was always going to cost £10,000.
Exactly. So the only surplus amount, if you like, is £3,000, and that's the amount that the claim should be for, not £5,000.
When you say the surplus amount is £3,000,
as in the difference between what they would have paid in any circumstances had they gone with the original builder, okay, and made the full payments, and the difference between
£10,000
between an additional the additional. Sorry, no, it can't be five.
No, you're right. You're right.
Yeah.
The claim value is. You see how tricky it is, folks.
Yes.
And a lot of people fall foul of it, and we have to really sit down
and do the
bleed
work.
blood through our foreheads
Yes.
sometimes. The claim value is £3,000.
The claim value needs to be £3,000. Yes.
We hope that's clear. If it's not, email us at hello@courtwingman.com.
We can provide a calculator.
Yeah, we can provide a calculator. Now, you can see that's a very simple example, but in most cases, in the cases that we've been dealing with, there's about 5 that I rattled off just before this podcast. There's so much more complexity, and so it is very easy to fall foul of that problem. How to cure this problem?
You will need to make a proper calculation of what you've paid, what you're expecting to pay. Just do your maths properly. Sit down with a piece of paper, lock yourself in a dark room, as I always say, and do your maths.
Yeah, and put your emotions to one side and just be cold and clinical like Dr. Spot and get your calculator out in a quiet room. But also, the point is that you can see how important the pre-action phase is. Because you might be being ignored by your opponent. So you might say, we say that the true claim value is 3,000, is 5,000, not 3,000 or whatever. So if you then issue and you haven't ironed that problem out beforehand, then you are sailing into expensive waters.
Yes.
Yeah. So you might not get a proper response from your opponent. But the important thing is you've got a letter somewhere that lays out clearly what the story that we've just illustrated.
And a chaser, ideally.
And a chaser. Look, we are bringing a claim for X. Do you agree or disagree that we owe you £2,000 for snagging?
Mm-hmm.
Because we don't think you do for whatever reason. And then you get ignored. You send a chaser. They ignore that. You immediately issue proceedings. Then you'll be so grateful for this advice if you get in front of a judge and the judge says, well, you've brought the claim wrongly. You say, well, yes, Your Honour, but we didn't know because the defendant refused to answer our questions pre-action on our correspondence, what was agreed and what wasn't agreed, what was paid, what wasn't paid, what were extras and what weren't extras. So it's really important in building disputes to exhaust, not exhaust, but to properly engage pre-action and get your calculator out. The other danger is, moving on from double recovery and whatnot, this is such an important area. What am I about to say? Don't
VAT.
whisper. Go on. This is an audience.
VAT.
No, I wasn't thinking so much about VAT, although obviously you need to factor that in. We'll come on to Cowboy Builders in a little while. Is what I was thinking of was track allocation. because everybody thinks that the claim is under 2,000, it's small claims, and if it's over, it's fast track. Well, no, that's just the normal track. If a court, you bring a claim for 5,000,
and it's complex,
and
there is an expert involved, and there's a counterclaim,
and there's a counterclaim,
exceed the amount.
Yeah, the counterclaim then suddenly can shoot the value way over the 10,000 mark, and then you get into a grey area, and you're in great danger. You know, to what extent do you include the counterclaim in the maths for purposes of track allocation? And a lot of building disputes start out as small claims and then get allocated to fast track.
And I think the danger of that is the clients tend to think that, you know, you can just come to court, you will tell your side of the story, the judge won't listen to the other side, and so it will be done and dusted in 2 hours. That's not how it works. The witnesses have to go into the witness box. There is a lot of process involved, and so it will never get done and dusted in an hour. And that's
2 hours.
Or in 2 hours, whatever.
Sorry, small claims track.
No, I'm just giving an example. You know, people tend to think that it can be just done and dusted in an hour and that's it. For whatever reason, you know,
no,
it's not as simple as that. Even for a small claims case, so up to, let's say, half a day, you know, you tend to think, oh, it's 9 till 1 or 9 till 2. No, that's not how it works again. And so if you've then got the counterclaim, and people have to be listened to, of course, because you've got witnesses. So your family members, builder and his subcontractors or mates or whatever, that's a day easily. At the very least.
And the court is not going to... so the court is not just going to look at claim value in such circumstances, particularly where there's an expert.
Exactly, yes.
Quite right. We'll just, because we're on the maths, we'll just now turn to Scott's schedules. Mm-hmm. Can you tell us about Scott's schedules, Daria?
I knew you'd ask that. So
we quizzed each other beforehand.
Yeah. So Scott's schedule. It's not always a requirement, but it just makes things easier sometimes. I think for clients to set out, for the claimant to set out what he thinks his claim is, for the defendant to say what it is that they're alleging, and ultimately for an expert to then make his comments and for the judge to make his comments. So in a nice sort of concise way, it's a table where the claimant is saying what is wrong, what the amount to remedy the defects is, what the defendant says, what the set-off is, what the expert says, and what the judge says. So it's a massive table.
So but I guess pre-action, you could draft one up pre-action and send it to your opponent. Could you?
Yeah, of course. There's
and then adapt it for proceedings once you're issued, include the expert, a column for the expert, etc.
Indeed.
And it will really help. Quite impress a judge, probably, if you're litigating in person, and he sees that pre-action you've actually produced a Scott's schedule to try and identify every single item.
Yes.
And the area in which it can become, where it can be important is, you know, where you say he didn't do the plaster work, and that's £1,000, and so you put that down in your Scott's schedule as £1,000 as part of your claim value. He says the only reason he didn't do it was because you told him to paint the wall and there was some timbers that needed to be replaced, and that cost him £500. So you can see how we're coming back to the value of the claim issue again, and dangers of double recovery, etc. Let's say you're the customer, you might not be aware that the builder is going to say, actually, it cost me extra not to do the plastering because you asked for painting, and whatever. So there is an example of a very simple Scott's schedule in Flying Solo, the book. And it actually is better to keep it simple, isn't it? I mean, you don't want to turn into an amateur lawyer. That's a big danger when litigants in person start to think that they're lawyers. Just keep it super simple. You were talking a little bit earlier about cowboys and builders, or you touched on it, Daria, and VAT and limited companies. What are the problems there? Because that's actually a very important question, isn't it? Yes.
So more often than not, people are contracting with someone. they aren't aware that that person has a limited company, or conversely, there may be loads of subcontractors, etc. And so the clients actually wish to make a claim against the director of a limited company because they believe that they contracted with that director rather than with the limited company. It poses all sorts of issues. Of course, the fallout from that as well is whether whether VAT should be payable. Because sometimes, the clients are being quoted, I don't know, £5,000 for the work. Ultimately, they're being presented with an invoice for £6,000, and they're like, well, hang on a minute. I was only meant to be paying £5,000. Why have I suddenly got an invoice for £6,000? So the builder will say, well, hang on. You contracted with my company. I need to pay that. I told you about that. No, you did not.
And this was all done on the back of a fag packet back in the day when everyone was happy with each other.
Where everyone is happy with each other. It's very grotesque the way these cases develop, because you start off as being best mates with your builder, and then you end up researching the love life on Facebook. That's pretty much what happens, unfortunately. It's quite normal.
That's an actual example from a case we've been running in the past.
It's normal to behave like this. We're all humans, and I can understand the emotions behind it. But the reality of it is you've got to sit down, do your maths, assess the circumstances, if necessary, get all of your documents together.
Well, can I just interrupt you there? I'm talking more about the issue of should you bring proceedings or not. Cowboy Builders. Because we've had some clients who've brought proceedings. Before you get onto the VAT issue, you've got the issue of whether or not it's worth bringing proceedings at all, isn't it? Against against a building company.
Yeah, that's correct.
And I seem to remember a case where we had about 5 or 6, 7, or even 12 different names.
It was 14, I think.
Was it really?
Yeah.
The builder had 14 different companies registered.
Yes, that's correct, yes.
But doesn't the law protect them? Isn't the judge going to say, oh, no, he's obviously a fraudster because he's got 14 different companies on company's house?
Well, does the law prevent having that many companies? The answer is no.
No.
So why is that an indicator of being a fraudster? And quite frankly, people do have a number of companies, and it's not an indicator of anything going wrong. It may be in certain circumstances, but if you haven't got cogent evidence to that effect, why would you even raise that?
Yeah, the problem is proving that it's fraudulent, because you see, the issue here is you really want to be contracting with an individual if you're a customer suing a builder. You don't like Joe Bloggs trading as Acme Building Services Limited. Sorry, it wouldn't be limited. Acme Building Services, trading as. Great. Sue the hell out of him. If it's Acme Building Services Limited, and then down the track, usually when you get in touch with us because you're in trouble, and we look it up on Company's House.
Incorporated 3 months ago.
well, yeah. And there's an Acme's Building Services Inc. or there's an Acme Builder Services, or there's an Acme Building Service, and they really
so
we've seen
on.
that, yeah.
We have,
and they'll
seen
just
this.
change a little word here and there. Really, that's the point at which you're probably going to have to say, going to have to put this down to experience, because what's going to happen if you sue them, they're going to go insolvent, and you are not going to get your money, and it's. Phoenixing, as they call it, is commonplace, but it's really difficult to deal with, and I'm afraid you're not, the government doesn't protect you. So be really careful. The test, because as often as not, you don't quite know who is the person you need to be suing. Is it the builder or is it an individual? Is who you thought you were contracting with. Because some builders will go, oh, yeah, do it with me, because they want to avoid VAT and tax and they want cash or something. And then later on you get a company invoice and you think, oh, I thought I was contracting with, well, he's covering his backside. Actually, you thought you were contracting with him. So at law, the law will support you, and he should be the one who goes down as the defendant.
Which then brings us back to the very beginning, even before you're doing your maths. do your research the company, look at who you're contracting with as well prior to doing any of this.
So here's a little issue. Leaving the site early, who pulls the plug comes up, doesn't it? And why is this an important issue? Let's give an example. A customer, locks his gates and doesn't let the builder come into the drive to complete the works on a certain day because they've finally had enough and they want to keep the builder off site because they've done a bad job. At least in the customer's minds, they've done a daft job. What are the danger? And then they go and get another company to repair to make good the negligent work. Negligent in their eyes, of course, but not necessarily in the judges yet. What is the problem of doing that if you're a customer?
Well, you will have trouble proving that the builder has caused the damage in question. That's one of the difficulties. Second of all, the law says that you
kind of want your own little mini expert to come in and take photographs and do a survey.
Second of all, the law says
work.
Yeah, the law says that you should allow people to try and remedy the work, and so they should be allowed reasonable opportunity to complete the works, to deal with any snagging issues.
Yeah, that's really important, quite commonplace, because you have actually repudiated the contract.
Cancelled. Terminated.
Yeah, repudiation being the technical legal word. Because you contracted with the builder for him to complete the works, you've kicked him off halfway through, you've then got someone else in to come and make good, and then you're then suing the builder for whatever, the additional costs, remember the double recovery point, that have been incurred, not the entire costs of the new builder, just the additional costs that have been incurred. And he says, well, they knocked me off, they kept me off site. As far as I'm concerned, I'm here. Maybe it's a year later. I'm ready to come on site and finish the work. He may even know that you've got it all, that you've already done the job. He might be playing a bit of a game, but he'll get away with it because you haven't given him the chance to remedy the problem. Mm-hmm. Manny, there are always, each case has to be judged on its own merits, and it may be that the rain's coming through the roof, in which case you try and get an expert in, or if you can't get an expert in to do an assessment of the works, at least take photographs, I guess.
Yes.
That'd be right.
Yeah, photographs. I mean, an expert would be great.
Well, let's talk about experts now.
Have we got time?
Yep, we've got time.
So with experts, I've been very impressed with a client recently who's done a lot of pre-action work, and she actually engaged an expert to comment on the issues. She, in fact, invited the builder to come to the property to sort of engage
she
with
got
the
a
process. She got the letter as well.
Perhaps she'd read our book.
Perhaps she has. I haven't asked, but I'm still assisting this client. Lovely lady, and she's really done her job very thoroughly. She brought the expert onto the side. She invited the other side. When the report was ultimately issued, she sent it to the other side, and the other side said, "Well, okay, we'll make our comments." Obviously, nothing happened, but she's really done her work very thoroughly. It's great. It will help her because she's done a lot of work. And so the whole process may be a lot easier for her because she won't find out much later down the line that actually the works are okay. She's already, gotten an independent expert to do an assessment, which is great.
Now, when should you get an expert in? Pre-issue, post-issue? Should it be your own expert or should it be a joint expert, etc., etc.?
Well, ideally, you should be getting an expert before issuing. Okay?
It can be expensive.
It can be expensive, and that's the issue. The other thing is your opponent.
Sorry to interrupt. Should that expert be agreed with the other side?
You should do. And the rationale for that is obviously you want someone that can later on say during the court proceedings, yes, I was independent, I was impartial from the very beginning of these proceedings, and even pre-action I was engaged by both parties, and so I'm preparing this report in anticipation of any court proceedings that may emerge from the circumstances.
And I suppose if your opponent refuses to engage with the expert process, you just have to go ahead and find an independent expert and draw the court's attention to your opponent's refusal.
There is obviously nothing preventing you from making an application later on in proceedings to say, this is an independent expert. I've engaged. I've done this. I've done that. Please, could I have permission to use this expert report? Okay.
And not have to get another expert in that's jointly agreed.
Exactly. Although, in these circumstances, 9 cases out of 10, the judge will say, well, let's get someone independent. So there is a bit of a risk. But conversely, you may end the case there and then, pre-action, because your opponent will say, well, sugar, I've really messed up. I better pay up because I won't just have the damages to pay up. I will also have costs, legal, including the legal fees, etc.
Okay, so thank you very much, Dara. I think that's a whistle-stop tour, folks. There's obviously loads to talk about. We'd love to have somebody on a podcast to talk about their case, just as we had someone on the other week for a small claims case that he'd won. We'd love to have you on so we can, make this really real and practical and give you a real flavour of what it's like to go through the courts with a building dispute, so that you can be sort of better prepared for the battle ahead, because litigation is a battle. So just to quickly summarise
is fine.
Just to quickly summarise, pre-action stage is really important. You've got to particularise your losses carefully. Use a Scots schedule if you can. That will help you deal with the problem of double recovery. Don't forget, this could be a fast-track claim masquerading as a small-track claim, or vice versa, depending on the size of the counterclaim. The value is just guidance for the normal track. It's not always the case, particularly in building disputes. Remember about not walking off site early if you're a builder, or not kicking the builder off. The question of whether a party is repudiated, the contract can be an issue. And think carefully about whether or not it might be prudent to instruct experts pre-issue. So I think that we will leave it for there. And just finally, where we started was, try and pin your opponent down on what was originally agreed in terms of scope and price, and what was then subsequently extras. And go into a quiet room for a lot of these phases. Don't get emotional and wound up about it. Try and step back, have a bird's eye view of your case, and do some simple maths on what, put yourself in your opponent's shoes. What is he going to say about that defect? And then you should be well set. And email us at hello@courtwingman.com, or go onto our website if you need help and assistance over and above the books and the videos and podcasts. That's goodbye from me.
Goodbye.